Annalise, welcome to HKA Talks To. So today we're joined by Annalise Day QC of Fountain Court, who's described as the leading lawyer of her generation. Annalise, thank you.
Thank you for inviting me. It's good to see you.
Perfect. And then I wonder if you could just start, just for those who don't know you, just to provide a brief overview of your practice and the type of work you're involved in.
So in normal circumstances, I have a pretty international practice. So I do cases not only in the UK, but obviously around the world, quite a lot of work in Dubai, Singapore, that sort of arena. And I specialise in construction, energy and commercial. So I'm one of the few silks who does kind of top end, both commercial and construction work. So that's pretty fascinating. And I also have quite a mixed practice, so I do about 50% court and 50% arbitration. So again, that's a nice balance. But obviously at the minute I'm here at home doing lots of virtual hearings around the world.
Excellent, thanks Annalise. I mean, given that your work has such a significant international aspect, I was wondering if you can just explore a little bit about, from an international perspective, whether you've seen how different jurisdictions, or whether different jurisdictions deal with the COVID issue in different ways, and if so, and how those differences might appear.
Yeah, so I think that the UK has been one of the leading jurisdictions in terms of keeping hearings going. So our courts were one of the earliest to say, basically, we're going to carry on, but we will be going remote. I think in Singapore, they've obviously passed some legislation which has provided for things like a complete freeze on liquidated damages, certain contracts for a certain period of time with a sort of different system. But that's only going to last for a short period of time. They've had some remote hearings, but not as many as us. And I know they're interested in our experience of it. And I think likewise in the arbitration sphere, I've seen a lot of arbitrations here going ahead. I think initially, when people thought it might all blow over more quickly than it has, that some people postponed things. But I think there's been an increased willingness to embrace the technology. And I know of, and I've been involved in, full-blown arbitrations with cross-examination of experts and witnesses that have taken place and that are taking place, rather than things having to be adjourned. So I think I had a hearing in the DIFC in Dubai, and that was by telephone, whereas of course here we've been doing everything by Zoom, Microsoft Teams, Skype for Business. So we have been more advanced, and it's interesting. There's going to be a seminar tomorrow that's going out to the international market that I think people are very interested in the UK's experience and how we've managed to keep things going. And I think it has been pleasantly surprising how good it is. I've also been involved in a few remote mediations, which have been remarkably successful. And the clients actually in some ways have preferred it because they don't have to travel somewhere, sit in a room with a load of lawyers. And, if you've got commercial clients, they know really what they want to settle something for. So it's less their time. So, yeah, a mixed response. But I think it's been encouraging that we've been able to kind of lead the way.
Yeah, it's really interesting. The point you make about the mediations is particularly interesting, just because a number of lawyers I spoke to were quite happy to have arbitrations and litigation conducted over video link, but they were a little bit more nervous about whether a mediation would work in that way, and they felt that you kind of that was the environment where, if anywhere, you would need that kind of face-to-face kind of contact and hands-on approach from the mediator as well. So it's interesting that you've conducted those remotely and they've been so successful as well.
Yeah, you need the right mediator.
Yeah.
And there are differences, but I still think it's a way of bringing people together, and there's less dead time. So, for example, in the afternoon when, offers, the mediator can tell you when he's ready or she's ready to come back and relay offers. So I think the clients have liked that, rather than once it gets to that stage. The beginning is very similar, having a plenary session, but again, it's down to the skill of the mediator. In terms of making the process work.
And on that point, I suppose the the enforced distance between the parties could have a cooling effect on the emotions between the parties. You know, mediations can get a little bit fraught at times, can't they? It's often because people are face to face, and perhaps the ability to sit remotely actually gives the parties a more measured and apathetic way to look at it, I guess.
Yeah, I think for the right type of dispute, I mean, obviously, if you have individuals involved, I think there's a real benefit to them having a physical mediation where they can see the other side and the other side can see them. But I think when you've got two businesses, people know the parameters of what they will settle at, and it's really a question of whether you can get to a deal with a neutral in between. I do also think that COVID has had an impact on what people may settle, their views on things. So I think that culture's changed a little bit, and it'll be interesting to see if more mediations can be more successful. I know that had come to a point where a lot of mediations didn't settle on the day, but then in the 2 weeks that followed, lots of them did. So, you know, again, it'll be interesting to see if that has a permanent effect.
Yeah.
Oh, okay. So as a kind of a trend that you've seen, you feel that people have, you know, there's been a greater willingness to settle or to find, you know, to find a deal that can be done in the current climate?
Completely variable. I've seen both a refusal, so a more hard line, and you know, I've certainly heard from some clients that their instructions are to be more hard line because they don't have the ongoing relationship sometimes. So that can also lead to deals being done. But if everything's stopped, then some people just think, well, I haven't got that to think about. But I have also seen people who want money, but not, I would say I haven't seen people who want money at any price yet. The issue will be whether that comes, but I haven't seen anything happening that shouldn't have settled before. But I think maybe some people sort of think, while we're fighting about this, there is a way forward, and we don't want to end up in costly litigation or arbitration.
Sure. Okay. So you sort of touched on the fact that you've conducted a number of hearings now remotely, you know, whether as arbitrator or barrister. I guess we're sort of keen to sort of how you found that experience, and what were your observations on the way the tribunal responded, whether you kind of adjusted your style of advocacy, and kind of what you made of you know, expert evidence as well, and whether you felt there were kind of any particular differences there.
Yeah, so I've done them both as counsel and as arbitrator, so I think it's interesting to see it from both sides.
Yeah.
I think, yeah, you've got to make sure the technology works, and because we're in the early phase, there've been a few kind of hiccups of making sure we've got the right systems that work and things like the bundling working. But generally, that's been pretty good, and the people behind the scenes have been amazing in terms of making sure it's okay for the sorts of hearings that I do.
Yeah.
I think the advocacy is definitely different. So the written documents that you submit become even more important, and I think your advocacy has to be crisper, you know, shorter to the point. People don't have the stamina to sit on a screen in the same way that in real life you might sit there. So I think you have to realise that and adapt to it. Cross-examination is also different because you don't have the immediacy, and one of the things is there is always a slight delay. So you can't interrupt in the way that perhaps you do. The flow can be different, and if you don't get it right, you end up with this terrible where people are speaking over each other. So I think that's really, really important. And obviously you also cannot hand anything up in the room, as it were. So everything has to be done in advance. I think for experts, I've seen both factual witnesses and experts, and actually, you know, for experts, it's a learning experience. Things like positioning the camera, making sure they've got all their screens, all their things that they need. I think the hearings I've done where we've been able to do sharing on the screen have been really, really helpful. And people have been able to follow on the screen together, going through something, which can be helpful if you've got a contract or a particular technical document, like a drawing or something. So I think that's a great thing to be able to do, and you can't do that on all systems at the minute. But yeah, I think people are going to need training, and I think they should practice, particularly experts or professionals, you know, giving evidence before they actually do it. You know, some of you have done it for years and years, but I think, you know, experts need to be trained at how to do it on a video link, because it is different. I think it can be as effective. I think what's also interesting is whether tribunals in particular may start doing things like calls with the experts in advance of the main hearing to try and make sure that experts are considering the same issues. I've got arbitration where that's going to happen next week, of whether tribunal wants to speak to the delay experts with just one lawyer present. So I think you may find some quite creative things happening. I haven't yet seen concurrent evidence on a video link. And that will be interesting as things get more sophisticated to see people doing that.
Yeah, okay. And I guess, so overall, do you think the process has been particularly detrimental to one party or the other? Or is it sort of generally just, you know, you think that it's been, you know, a fair and even process and no one's been hindered as a result?
Generally, I've been very, very impressed by the judges and the arbitrators that I've been in front of in terms of ensuring that everybody has a fair opportunity. And when there have been a few technical issues with people dropping off, they've been very, very understanding about that. I think the people who adapt faster may have a little bit of an advantage, as with anything. I don't think it's an unfair advantage, but I think it's a different skill set and it's an adjustment, and some people are adjusting quicker than others.
Sure, okay. And so sort of moving on and sort of looking at the financial impact of the pandemic, I mean, do you think clients will look at alternative ways to finance their disputes going forward? And if so, do you see this as a way to sort of protect their cash position, a way to expedite proceedings, or sort of a combination of the two?
Yeah, I think they definitely will. I've already had clients also talking about, you know, having different forms of dispute resolution that are not mediations or a full hearing, but bifurcation of issues. So again, in some ways, if you have a remote hearing, it was easier to organise a sort of mini hearing on particular issues. So I've certainly had clients, you know, wanting to explore those options as a way to cracking a dispute. I think in relation to funding, that people are also asking in the market whether there may be ways of having both the claims they're bringing and defending claims, you know, involving a funder, whereas in the past that wouldn't have been something that they would have considered. So I think people are going to get creative, and obviously if we get to a stage of a lot of insolvencies, then you're going to also have other people in charge of claims, the possibility of claims being bought and sold in a market. Again, there's some of that already, but there may be people who are willing to do that. So, or even judgments and enforcement of awards and judgments, which is already a reasonable business in some areas. But again, you might see that coming to the fore. So I think there will be a changing landscape. I think at the minute, because people don't quite know how long it's going to last and what the impact will be, difficult to predict, but I think definitely people will seek to adapt.
Do you think there'll be sort of an increased willingness at the bar to look at you know, taking cases with some element of risk involved, you know, whether that be a DBA or CFA, something like that, where, you know, there's a bit more of a kind of having skin in the game, as it were?
I think that will remain a very personal choice for people, as it is at the minute. I mean, there are people who before this crisis had done quite a lot of that work and people who just didn't go near it. So obviously if it becomes the default way of funding, then people will have no option. But I think there are mixed views and mixed thoughts on it. I've never seen anyone pressured into doing something that they didn't want to do. But yeah, I think everyone needs to be flexible and creative and have an open mind about things.
I was thinking, Annalise, moving on, we've talked a lot about what's happening at the moment in the industry, in the sector, but obviously the million-dollar question is about what's going to happen afterwards, what's going to come out of the pandemic and how companies and how the sector is going to react to that. So I'm interested to understand, from your view, once the restrictions have been lifted in full, whatever that quite means at the moment and when that's going to be, we don't know. But do you think there will be any permanent changes to how the legal and construction community operate and interact? So, for example, are there any positive lessons that could be taken away?
Yeah, I mean, I think having used the technology, people will realise that when they used to get on a plane and fly to a meeting, it really may not be necessary. I mean, obviously, for hearings, I suspect there will still definitely be a place for in-person hearings. But for example, for procedural calls, for, perhaps having expert meetings in advance, either with or without tribunal and the parties, I think there are lots and lots of things that can be done efficiently on a video. But I think there are some things where, there is no true substitute for people being there together. But I think the good thing is it's shown us what the technology can do. I also hope that the electronic kind of bundling and use of documents being stored electronically and being able to be used by lawyers electronically improves massively, so that becomes, particularly for international work, who wants to send bundles to barristers in hard copy, and I think hopefully we'll see only core documents that really need to be being printed out, and the rest being able to be sent and viewed, and we'll save a few rainforests through doing that.
Sure.
But I think those systems need to become cheaper, easier to use, more accessible, and I hope that this will provide the impetus for that to happen, which people have been talking about for 20 years since I've been doing it. And likewise on, construction sites, whether there'll be an improvement in paper records and all those things that people traditionally have used and lost, whether we'll be able to see a more sophisticated way of recording it that can be used when claims arise in a more user-friendly way than often happens at present. But we'll see. I mean, the industry's been quite reluctant, I think, to that happening. But certainly, I think with a lot more people working from home, I think what will happen to law firms and businesses, will they have a lot more people working from home? So having remote systems for dealing with that is likely to be essential, and hopefully those systems may be of some use to claims. On the other side, on the downside, we're just going to have reams and reams of electronic material wade through. So storage of them in an efficient way is going to be really, really important. But I think for the hearing, there is nothing quite like having everybody there for a hearing. But in international cases, I think it will become more acceptable that if a particular person can't travel, to have their evidence dealt with remotely, and again some creative use of the technology to try and resolve things before you get to the full-blown hearing. And sometimes full-blown hearing is the only way forward, but maybe having some hearings with experts early on might streamline the issues and lead to a resolution. I think a lot of people have also asked about, new arbitrators and whether this is a chance for younger people, a more diverse pool of arbitrators who might be more able to deal with the technology. And I think that's a great opportunity for people, particularly on lower value disputes, who might be able to make a name for themselves, by providing a service that doesn't really exist at the minute, because they have, the full blown arbitration. There isn't a lot in between. So again, I think those sorts of things hopefully will become more developed. We might also all appreciate each other a bit more. Can be tough, but who knows? I do think one thing I've been very aware of is, having boundaries between home and work will be more difficult when people work from home. And I think we need to be conscious that we don't end up with people being burnt out by being expected to work all the time. So I think that sort of work-life balance, it can sound as if it's better when you work at home, but actually I think as a lot of us have found, there's then no division. And I think that will be important to keep people, feeling okay and functioning, to have that and to have contact with real humans sometimes, not just on the screen.
Well, there's certainly a lot to be said for it, isn't there?
Yeah, I've also heard a lot of people saying, you know, the management, I mean, as a barrister, I don't have this as much, but obviously the management of a firm or a company, when everybody's remote, takes a lot of time for the management to make sure everyone's okay and checking in. And so, you know, I think there's a place for it, but I think it will be used in conjunction with other things, assuming we can get back to something a bit more like normality. I certainly know the courts in England are moving to looking at ways of perhaps having, you know, lead advocates and judges in the same place, or at least having more people in the same place in a socially distanced way. But it does create that kind of ability to have a mix and match approach, which would have been unthinkable, you know, pre this. You know, people's mindset was quite fixed, and video hearings were always seen as, you know, the last resort. So I hope what happens is they become added to the, you know, list of ways in which a dispute can be resolved effectively. But again, it's going to depend on each case, and not having a rigid mindset, but really thinking creatively about what's the best way to resolve this dispute to best affect all concerned, which is ultimately what clients want.
Absolutely.
That's it. Brilliant. Okay, Annalise. Well, thank you. That's the last of our questions. So thanks so much for joining us. It was really, really insightful, and you know, we look forward to keeping in touch.
Absolutely, and thank you for hosting this series. It's a great idea. So
yes, thanks very much. Good to catch up, Annalise.
Yeah, brilliant.